Good morning, everyone. I'm Mike Danaher. I'm an Assistant Attorney General with the New York State Attorney General's Office. We come out to Cornell Cooperative Extension on a monthly basis to talk about various consumer topics that people are faced with. And one of our big topics is talking about landlord and tenant issues. Just to start out, for those of you that would like to have written information related to landlord-tenant issues, our office has a brochure available called the Tenant's Rights Guide. It covers all of New York State, so it has some issues related to housing in New York City that doesn't necessarily apply up here, and it has some general information related to landlord-tenant. All of the brochures from the Attorney General's Office are available online at www.ag.ny.gov. And for those of you that don't want to write that down, just put up in your browser, New York State Attorney General's Office, and you'll find it. So again, one of the big topics that I deal with in the Attorney General's Office and the consumer mediation staff are landlord-tenant issues. Frequently, the problems that occur with landlords and tenants is as a result of a miscommunication that has occurred between the two sides. So we're going to talk about a few things that may assist in that and hopefully resolve a lot of the issues that may particularly come up. So kind of fundamentally what we can talk about is the landlord-tenant relationship. Is the fundamental question being, what is a lease anyway? Well, there's really no good definition of what a lease is other than the fact that it is an agreement between a landlord and a tenant whereby the landlord agrees to rent a certain physical space to a tenant, and the tenant agrees to, in essence, treat that space as their own for the length of time that the agreement exists. One question that comes up frequently is, do I have to have a written agreement? And the answer is, from a straight legal perspective, most residential leases do not have to be in writing. However, from both the landlord and the tenant perspective, it is so much better that if the parties enter into a written lease. The general rule in New York is that any lease for a year or less does not have to be in writing to be enforceable. If you're going to lease an apartment for 2 years, which I don't think I've ever heard of leases going that long, but if you were, for the agreement to be enforceable for a term longer than a year, it should be in writing. There's a thing called the statute of frauds in New York, and it's everywhere has a statute of frauds. But in order to avoid fraud occurring and somebody walking in and saying, hey, we have a 10-year lease, anything in excess of a year needs to be in writing. But most residential leases are for a year or less, so there's usually not a problem with that. However, that being said, although the written agreement is not required, I think you would be crazy to enter into an agreement without it being in writing. Now, when I first started talking here today, I said a lot of the problems occur because of a miscommunication between the two sides. A lot of that miscommunication can occur because they don't write down what the parties actually agreed to. How much easier would it be and less of a hassle if during the winter time the sidewalk is not being shoveled and the landlord comes in and says, well, it's the tenant's responsibility because that's what we agreed to. And the tenant says, well, no, that's not what we agreed to. We agreed that either we didn't agree to anything or that I you said that you were going to take care of these sorts of things. Those things can all be resolved if you had it all in writing, because then the question could raise, who's in charge of doing the snow removal? Well, you can pull out the document, and if it says right in there the tenant's responsible or the landlord's responsible, how much better is that? Then there's no question. Another huge issue is pets. You, tenant, bring in Fluffy, the dog, and the landlord says, you can't have Fluffy, and the tenant says, well, yes, you said I could have Fluffy, and here's how the conversation went down. The conversation went down is, I may be getting a dog in the first year that I'm leasing the property, and the landlord says, well, we'll talk about it when that happens. What the landlord is saying to you, tenant, I just got to interpret this language. What they're saying to you is, no, you can't have a dog, but maybe I'll think about it later. Where, what the tenant's thinking is, the landlord just said yes. This can all be resolved by in the document saying no pets allowed, or pet, Fluffy can come in. Because and this is the other thing that I need to point out to tenants. This is very crucial in the term. When the lease says no pets allowed, you'll never guess what that means. It means no pets are allowed. So even though you brought this pet in that you love to have and is the nicest pet, and the landlord has seen the pet there, that doesn't mean the landlord has agreed to it. If your lease says no pets, it means no pets. It doesn't mean, oh yes, we can have a pet because my parents are going to Florida for a month, so I can take over their pet. It means, strange as this may sound, no pets means no pets. And it would be a breach of the lease agreement. And how much better is that to protect everyone's interest to say, if it says no pets, it means no pets. It doesn't say no pets except you can have your parents' pets for up to a month. If that's what you anticipate happening, put a comma at the end of the sentence, change the period to a comma, and say, except for my parents' dog that I will have from January 1 to January 31. Then everybody knows. And if you put that in there and the parties agree to it, and then your pet comes in on January 2nd, your parents' pet, and the landlord comes and says, it says no pets, you can pull out the document. And it says, no, but here it says that we can do that. Put everything in writing that can possibly be. Who's responsible for maintenance? Who's responsible for utilities? Who's responsible for cleaning off the driveway? All those sorts of things should be added to the lease so that everybody knows where they stand. Now, there are some provisions that the landlord may want to put in the lease that are not legal. And we'll talk about those as we go on. But even if it's not, put it in the lease just so that everybody understands what the deal is. And then if it proves that something is not supposed to be in there, then the way the law says is that those particular provisions are void, meaning they're stricken out of the lease. So get everything in writing. The laws related to landlord and tenant issues are all over the place. They would be nice to have them in one nice little section of the law that says landlord-tenant rights and responsibilities, article whatever of the real property law or the real property actions and proceedings law. But they're all over the place. There are laws related to tenancies in the real property law. New York has a real property law. New York has a general obligations law that just deal with general obligations that are out there. That has some issues. It has some coverage for landlord-tenant. Evictions are covered by what we affectionately refer to in the law as the RPAPL, which is the Real Properties Actions and Proceedings law. There's also a multiple dwelling law that could have some impact. There are also local ordinances, mostly in New York City, that deal with rent stabilization, those sorts of things. We don't have that here, but there are in some municipalities. Let's talk about, there's really associated with leasing, there's landlord's obligations and tenants' rights, but surprisingly there's also tenant obligations as well. So each party, landlords have rights and responsibilities, and tenants have rights and responsibilities. And we'll talk about those as we go through. First and foremost, let's talk about the landlord's obligations. And the landlord has an obligation under the law to provide a habitable residence. It's actually referred to as a warranty. It's the warranty of habitability. The landlord must provide a habitable residence for the tenant, and generally that is, it's livable, it's safe, and it's sanitary. So what are the basics that we would expect when we live in a place? And that is, one is to have water, hot water, and heat. Those are an obligation of the landlord. Now, the landlord does not necessarily, depending on what the agreement of the parties is, have the obligation to pay for those items. That, again, is part of the lease negotiation. So it might be that the landlord is obligated to provide the heat. In other words, the furnace has to work and all that. But the landlord doesn't necessarily, depending on how the parties agree to it, have to pay for the gas or electric or propane or fuel oil. That may be part of the obligation of the tenant, depending on, and then we fall back to it, let's put it in writing, who's responsible for doing what. So if it's the tenant's responsibility to pay for the fuel oil, let's say, to heat the apartment, then if the heating oil runs out, that's not the landlord's fault, and that's not a breach of the warranty of habitability. If, however, the furnace breaks for no reason of the tenant causing any damage, it is incumbent upon the landlord to make the repairs. And we'll talk about that in a little while. If the landlord does not comply with the warranty of habitability, it is a breach of the agreement, and the tenant has various avenues to try to handle that problem. And that would be the landlord could, or the tenant could pay to have that fixed and seek reimbursement from the landlord in the way of either suing the landlord to get the money back or deducting it from rent, future rents to cover that, or because it's a breach of the warranty of habitability, the tenant can actually, let's say the tenant's on a one-year lease from July 1st to June 30th, and in January the furnace breaks, and the landlord has been given reasonable notice and they can't get it fixed, or doesn't fix it, doesn't do anything. The tenant has every right to move without being obligated to fulfill their further responsibilities under the remaining term of the lease. Because once a party to the agreement, whether it's tenant or landlord, breaches the agreement, then the other party is absolved of their responsibility to follow up with their obligations under the lease. Another thing the landlord could do is say at the end of the lease they've had $500 in expenses that were habitability issues that the landlord didn't cover. They could actually go to court, and although they've paid the lease all along, they could go back to court and say, hey, or one, they could do ahead of time and say, I need a reduction in my rent because I paid for this particular thing that wasn't provided to me. Therefore, my value of my lease is reduced because I didn't get it. And the court would have to determine what the value was that the tenant lost and be able to recoup that as well. How do we handle these situations? Let's say as a practical matter, how do we handle these sorts of things? Well, number one is it's very important to communicate. I know there are some instances where the communication has broken down and the parties can't seem to even speak to each other. The fact still remains the easiest way to try to resolve this is by communication. And discussing it with a landlord is crucial, and try to get a hold of them. Now, how long would the landlord have to fix this problem? And the answer is a reasonable period of time. And so we said, oh my gosh, what's reasonable? Well, the term reasonable is often well defined by lawyers in the courts, making what's reasonable. But I think if you really sit back and think about it, most of us within certain parameters can come up to what's generally reasonable. And you say, that's terrible. If let's say I'm supposed to be provided with air conditioning, and the landlord isn't providing the air conditioning, something broke or something. The law should say they have X number of days to fix it. And I say to you, okay, how many days should it be if the air conditioning breaks on February 1st? Okay? Let's use heat. How much is a reasonable period of time to fix the furnace on July 1st? Okay, let's flip that around. Talking about heat. How much is a reasonable period of time on January 1st to fix the heat? I think we would all agree, being reasonable people, that the time period of reasonableness is different depending on the circumstances. It is much shorter on January 1st for heat and much shorter on July 1st for air conditioning. Although, I do have to say, one caveat, air conditioning is not required. Okay? Air conditioning is not required. Heat is, so let's stick with the heat. Heat is required. So the reasonableness on January 1st for fixing the heat is much different than if you notify the landlord on July 1st that the furnace just blew up or something. So that's why the law gives a reasonable period of time. So what needs to happen is, as a practical matter, the tenant needs to contact the landlord and put the landlord on notice. I would encourage all tenants to write down all attempted communication for warranties of habitability, so that you can show, because we're talking about a reasonableness standard, you can show that you acted reasonably. Say, I notified him on January 1st at this time. I called him 4 times that day, once at this time, once at this time, once at this time, once at this time. I still haven't heard back from him or her. I called again on January 2nd, and then they didn't call me back, so I called a repair shop and they came out and fixed it. Or I had to go live somewhere else, or I moved out or whatever. So I leave it up to, most people are reasonable. I leave it up to those people who are reasonable to make a decision as to how long that period of time actually is. If the landlord must be given notice. You can't just immediately, you don't have heat, your heat broke, you just move out. You got to give the other side a reasonable opportunity to fix it. If they don't fix it within a reasonable period of time, the tenant can do the things that we talked about before. That can deal with any type of habitability issue. You don't have water, the roof is leaking. I guess it comes down to a question of, if the roof is leaking, if it's not causing any damage to your stuff as a tenant, then it's really only the landlord's problem, because the landlord is losing the value of their property if they don't come and fix it. And landlords are crazy to let their investment deteriorate, and some of them don't care sometimes, and some do. So that's really up to the tenant. If it involves habitability issues in the sense that there's a room now that you can't use because water is infiltrating it or something like that, that's the question then comes down to is, has it impacted the tenant's ability to reside in the premises? Well, maybe it's a room that isn't necessarily needed that often, and they can continue to reside in the rest of the apartment. Well, in that case, then the tenant might be entitled to a rent abatement of some sort for that non-use, but it may not affect the warranty of habitability. I have to leave up to you to make the determination whether or not that affects it. For example, if it causes a water stain or something on the ceiling, but the ceiling's not falling in or something, then those are two different things. But if it's leaking in the middle of the family room, maybe that is. That's an interesting question. What happens if there's a natural disaster which causes the tenancy to be uninhabitable, let's say, for an extended period of time, and through no fault of the landlord, it cannot be corrected? The question then really comes down to money, is who's responsible for that length of time that it's out? And one, it would be, I think it would be harder on the tenant's part to get out for a breach of the warranty of habitability since it's out of the control. However, it's an undecided question as to whose financial responsibility is that. And that's something I think I would have to leave up to the parties to try to discuss. I think that the landlord and the tenant both have to recognize that there is no fault on one side or the other, because it's not the landlord causing the electric to be shut off. It's a natural disaster. And I know that in my case that my mortgage payment doesn't change if I can't live in my house for any length of period of time. So why should it necessarily be falling on the landlord? But there really is no set determination. There's arguments on both sides, because the tenant situation is not an ownership interest, and they could very easily say at some point in time is, I still need a place to live, and part of the reason why I rented was to avoid circumstances like that. And I can see the argument saying is that's a cost of doing business on the part of the landlord side. So there's no definitive answer there, and it would actually have to be decided by the courts. So I would say to the people is you need to sit down and discuss that sort of thing, and landlords need to understand that that's one of the costs of doing business. As far as Section 8 goes, what I would tell people is that there are requirements. There is usually an agreement that those who are seeking assistance for the funding of their leases, they should make sure that they're aware of what their responsibilities are and what their rights are in relating to either qualifying for Section 8 funding or what the obligations will be if you do qualify for those sorts of things. I'll throw on the other side. Also, the landlords have to be aware of what their obligations and rights are with respect to if they are taking in income as a result of Section 8 housing. So they need to be aware of what their rules are, but that's not something that we're going to discuss here today. Another issue that comes up is what happens. Let's say you're in a multiple dwelling unit, not this definition under the law of multiple dwelling, but one that involves more than one other tenant in the property. What do you do as far as noisy tenants, and who's the one that's responsible for the next door neighbor causing all kinds of a racket at 3 o'clock in the morning? And the way I pose it is it's not the landlord's obligation to control noise. I have you think of it as if you were the owner of that particular apartment and somebody else owned their particular apartment. Let's say it's akin to you living in a house and then there's somebody next door. So if you were the owner of that house and somebody next door was making a racket, how would you handle it? Sure, I would tell you to put your landlord on notice because the landlord needs to know those sorts of things. But you just handle it in that same way. As you call the police and you say these people are having a party at 3 o'clock in the morning. I have to get up to go to work the next day, and notify them of that. It's not the landlord's responsibility per se. However, if it rises, I've heard some say that if it rises to a repeated, persistent thing, it could be construed as a breach of the warranty of habitability of living there. And an argument could be made that lease provision is being violated so that it would give you the opportunity to get out of the lease. And let's step back and talk practically as well. Landlords, in a landlord's mindset, there is nothing better than a good tenant. Nothing better. one who pays rent on time, keeps their property up. There is nothing worse than a bad tenant. And landlords want to know, because the landlord doesn't want, in a 4-unit place, one person causing a problem that's going to have 3 other good-paying tenants leave. So the landlord wants to know that, and the landlord will do something about it if they're going to lose 3 tenants because of one in particular. So as a practical rule, call the police, let the landlord know it could rise to the level of a breach of warranty of habitability. When we're talking about habitability, what is habitability? That's a frequent question, is what is a habitability? I had tenants who have complained to me saying that the landlord said that he was going to make these repairs and make it really nice and put in the new carpet, and he hasn't done it, and it's been 6 months, and I don't like it, and it's a breach of warranty of habitability. Warranty of habitability is basic housing. It's not pretty carpets and new window treatments and new windows and all that stuff. If it's habitable, it's habitable. These other things don't rise to that level. Now, it might be a breach of your agreement, your contract, which of course, being the great tenant that you are, you're going to make sure that it's in writing saying that there's going to be new carpeting installed by a certain date, or new windows or whatever. You'll put it in there so everybody knows, because what ends up happening, you say, well, you breached my agreement because you said you're going to put in new carpeting, and the landlord can say, where in the lease does it say I'm going to do that? Well, you promised. Well, you know, I am going to eventually do that. Okay? Get it in writing. So warranty, I generally think the best guide of habitability issues, although not set in stone, but I think a good guide for landlords and tenants is code. Does the apartment live up to the standard of code as far as housing issues are concerned? You know, if it violates code because of, I don't know, dangerous conditions and lack of heat and that sort of thing, I would rely on code. And you can call code to have inspectors look to see if it's living up to that level. Now, there's certain rules in the state statutes regarding this. Heat's got to be on at a certain period of time, like October to April or something like that. I don't have the exact dates, but it's in our tenants' rights guide. So that's another reason for you, again, available online, or you can contact my office and we can send you a copy of this as well. This applies to both upstate, and it has New York City issues in it as well. It's a combined thing. When I say it has New York City issues, it has rent stabilization references to the New York City housing code that may not be applicable upstate, but it has the general rules as far as what warranty or what heating requirements are, what the succession rights are, what subletting rights are. All those sorts of things are contained in there. So I would refer that to you. As far as code issue goes, if you're doing a house sharing as compared to a separate apartments sort of thing, does the code here require that there be inspections done? I don't know what the local code in Tompkins County or City of Ithaca is, so I can't speak to that. I would tell you the best thing to do is to contact the code office to see if there are. As a general rule, the state laws are less stringent for those owners who are continuing to reside in their particular properties, whether it's a sharing or a duplex where the actual landlord lives on one side or lives within it. They're usually more relaxed standards than some of the other rules are. But in particular, I can't speak to what the specific code is. I would suspect there's probably less stringent code requirements and inspections for landlords who live in their place and rent a room out to somebody. Another question that frequently comes up is with security deposits and the landlord's obligations with regard to security deposits. And you can answer a lot of your own questions related to security deposits if you know one fundamental fact, and that is the answer to the question of whose money is the security deposit. So once you know the answer to that, you can probably answer a lot of the questions that I would ask you related to how that security deposit should be handled. There are some rules that apply to it, but in how it's to be handled is that if you know who is the owner of those funds, then you can make a lot of those questions go away. So who owns the security deposit? Whose money is the security deposit when it gets paid over to the landlord? It's the tenant's money. So if you know that it is the tenant's money, you can answer a lot of questions I would ask. For example, can the landlord take the security deposit that a tenant has been paid and put it into his checking account? The answer is no, and the reason is because it's not his money. So the rule is you cannot commingle somebody else's money with your money. So landlords need to keep, in any circumstances, whether you're just renting out a house or you're renting out a 12-unit apartment building, you cannot take the money and put it in your own pocket. You cannot do that. There's a fundamental reason for that, and I see it happen all the time. And that is that when you take somebody else's money and put it in your own account, it somehow psychologically becomes your money. And it's like using a crowbar to pry open your own bank account to have to give somebody the money back because you think you're giving them back your money. Well, you're not. You're giving them back their money. So you have to keep it separate. Now, there are certain rules related to it. Well, let's keep going on. There are different ways you can handle a security deposit. Let's assume for the moment that you put it into an interest-bearing bank account. And, of course, it's not commingled with your own funds, of course. And there's interest that is accumulated on that bank account. Who gets the interest? Who gets the interest? Why? Tenant gets the interest because it's the tenant's money. Now, there is a caveat to that, and that makes this question more of a academic question. Is the law does allow the landlord to keep 1% as an administrative fee for administering the accounts. Now, when I first started coming out and speaking to Cornell Cooperative Extension over 16 years ago, this was less of an academic question because actual interest rates on bank accounts are like 3%. So the landlord could keep 1%, but the remaining 2% would go to the tenant. Now the interest rates are so low that in actuality they're usually less than 1%. So the landlord could end up keeping it if they should so desire because of that. But the fact remains is that the interest does belong to the tenant, but then the money could be paid over to the landlord as an administrative fee. And likewise, let's assume for the moment we do get to a place where interest rates go up and it's more than 1%. And so let's say that it is an interest-bearing account, and so some things can happen. For example, the landlord could give the interest back to the tenant annually, let's say, or monthly, or the landlord could say, well, we'll keep the interest until you vacate the apartment. And maybe you don't vacate the apartment for 5 years, so it's just accumulating over a period of time. Now, I haven't heard of a lot of tenants retiring and living off the income on their escrow account, but the fact still remains is maybe it's $10, $15. What obligation does the landlord have to a landlord who uses federal funding to build the housing? What obligation he has to renew a particular lease? And the answer is it depends on the funding source. If the funding source requires them to offer renewals, then they have to. But as a general rule, landlords are not obligated to renew leases with tenants.
In New York State.
In New York State. I am not talking about New York City. I am not going to talk about New York City.
I don't need to. I'm talking about New York State.
So in New York State, the general rule is a landlord is not obligated. And people say, well, that's unfair, and I've lived here for 6 years, and I lived here for 10 years. But let's flip it around. What obligation of a tenant, a good tenant, to stay? Well, if a landlord is obligated to let you stay, why shouldn't a landlord be allowed to make you stay. So it's actually an equal thing. It's he or she owns the property. Being he or she the owner of the property, they can choose who to rent and for what period of time because they own the property. The landlord or the tenant, at the expiration of the lease, can walk their separate ways. There is no explanation. However, the landlord cannot refuse to release, not release, let go, but re-rent the property for because of retaliation and because of discrimination. So you can't refuse to re-rent because of age, race, sex, sexual orientation, etc. You can't refuse to rent or re-rent because of a suspect. They refer to it in discrimination as a suspect classification. If the person falls within a suspect classification, you can, a disability, whatever it happens to be, you can't refuse to rent to them for that suspect classification. Same with re-renting. Or retaliation. You can't refuse to re-rent because the tenant called code and there were code violations. Now, tenants, this is a thing out there. Tenants, code is there as a shield, not a sword. Some tenants have been known to thinking, how about if near the end of my lease, I know the landlord's not going to re-rent to me because, for whatever reason, the landlord's daughter's moving back to town and needs a place to live. So I'm going to file a code complaint against this landlord so that then, even though there's nothing wrong, because then I'm going to claim that he's retaliating against me and won't re-rent to me. Can't do it. Retaliation is as a result of a legitimate complaint that gets filed. The landlord can't use that to say, you're a pain in the neck because you're filing things, you're retaliating and preventing it. Then we fall back to the question of, is it retaliation or not? That I can't answer. That's up to the court to decide. It's a question of proof and whether or not that exists. So that's the circumstance. As a general rule, landlords are not obligated to re-rent. As a general rule, tenants are not obligated to re-rent. So it's levels the playing field. So getting back to our security deposit issue, landlords have to understand that security deposits are not additional rent. We'll get to the tenant's obligations in a few minutes. So it can't be used as additional rent. It always remains the property of the tenant. If there are more than 5 units, in other words, 6 units or more in the complex, the landlord must put it in an interest-bearing account in a New York bank. I had a case at one point in time where the landlord was out of New Jersey. It was a big complex, and the landlord, this is the next question I asked you. There's all those different options that the landlord has to say, well, we can do this. We can give it back to you at the end of the lease. We can give it to you annually. We can have you get your interest back monthly, however you want to do it. Whose choice is it as to how that gets affected? Can the landlord say, the landlord says, okay, we have your security deposit, it's an interest-bearing account, it's earning 2%. I'm not going to take, well, I'll take 1% as administrative fee, but you'll get 1%. What I'll do is I'll return it to you when you finally move out. It's a pain in the neck to handle this interest thing. I'll just give you the interest back when you move out. It may be 5 years, maybe 10 years, maybe 15 years. I'll give it back to you. Whose choice is how that interest paid out? It's the tenant. Why? It's the tenant's money, and that is true. And I actually had a case where the landlord said, okay, this is what we're going to do. I'm going to put it in, I'm a New Jersey limited partnership. It was a big complex. It was a big dollar value. Many units. This is a pain in the neck. So what we'll do is I'll give you, it's in an interest-bearing account in a New Jersey bank, and I'll give you your interest back when you ultimately move out. And I went after them because it's not their call. It's the tenant's call. And the rule is if you pay it back to the tenant on a year or more frequently, then they can do it that way. Otherwise, it's pretty much the tenant's choice. The tenant can say to you, fine, it's a pain in the neck to me, it's $5 a year. Just keep it going, and then when I move out, ultimately you can pay it back to me. That's fine, as long as it's the tenant's assent to do that. But if the landlord says, look, we'll pay it back to you at the end of the 5 years, 10 years, whenever you ultimately move out, however down the road. And the tenant says to him, no, I would like it every year. The landlord must do it because that really is the tenant's choice. So if it's 6 units or more, it must be an interest-bearing account. If it's 5 units or less, it doesn't have to be an interest-bearing account. However, it still can't be commingled. Always got to be kept separate. I use the example that let's say you pay it in cash, so it's $500 you give as your security deposit, and the landlord takes out his money clip and puts it on with his rest of his money. Well, that's really commingling it with your money. I say put it in the other pocket. And if you keep your money in your sock drawer, your own money in the sock drawer, then put the tenant's deposits in the shirt drawer. Just keep it separate so it's easier to pay back at the end. Upon the sale of the property, this is a frequent question that comes up. Upon the sale of the property, the buyer of the property takes the property subject to all existing leases. So whatever remaining term of the lease exists, the buyer takes it. Also, sellers of property. Make sure that when you do the closing, that you transfer all your security deposits over to the new tenant, new landlord, and keep a record that that took place. So usually it's done when all the money gets sifted across with all adjustments and stuff. It's part of the real estate closing adjustments usually. Make sure your form says that the security, this amount for Jones in Unit 1, Smith in Unit 2, goes over in the adjustments to the new landlord. New landlord, make sure you immediately take money out of that transaction and put it that you got in security deposits and put it in a separate account. That's not your money, even though it's all washed out in the end. Pull money out, put it in the account, and make sure that it remains separate. Because sellers, we'll talk about sellers. Unless you can do that and document that, you remain on the hook. You're selling the property for a reason. So get rid of all the reason. Transfer it over. Otherwise, if you don't and can't document it, you are on the hook for those deposits. And it may be a year down the road. It may be 2 years down the road. It may be 3 years down the road when the tenant moves out. And the new landlord says, well, I never got the security deposits. The original landlord could be on the hook. You don't want that hassle. Get it all separated. Keep a document so that when the new landlord says, no, I never got it from the old landlord, the old landlord can say, yes, you did, because here's the closing sheet and it shows the money came over to you. Then the new landlord is on the hook. So make sure you do that. Also, like I mentioned, the obligations of the landlord still carry over so that the new landlord has the obligations of the prior landlord. So let's say the new landlord buys the property and there's existing leases that still have 6 months to go. They buy it subject to those existing leases and are bound by those terms of those leases till their expiration. And then once it expires, they can work out a new deal or whatever. So everything should be transferred over. So we talked about the landlord's obligations. We can talk about the tenant's obligations, because lots of times we talk about there's landlords or there's tenants' rights, and there are. And I'll fall back to it. This is a common theme that I've talked about almost monthly here at Cornell Cooperative Extension when we talk about consumer issues. Is a lot of the laws that are set up for any consumer-related issue is not designed to give one party an advantage over another party. It's really designed to attempt to level the playing field, not to give anybody any superior rights. Similar to the fact that we talked about, at the end of the lease, the landlord doesn't have to renew. Well, the tenant doesn't have to renew either. So the laws that are set up are designed to try and level the playing field to the extent that it can be possible. So the tenants have obligations as well. Because of the situation, it's usually the tenants that need to have the protection of the laws as far as the relationship goes. But the laws are there to protect the landlord in the sense that, what happens if a tenant destroys the place? And that will happen. Tenants destroy the place. Then the landlord has the right to sue the tenant for any damage that occurs. I mean, that's just fair. That's the right thing. So tenants also have obligations. So one is pay the rent, and pay the rent on time. Tenants have to understand. They think that this is the big bad landlord, and they're rich. Sometimes that's a distorted view, but they're rich and they have all the power. But landlords have obligations as well. They have mortgages to pay on these properties. They have expenses to be paid for on the properties. So they're entitled to receive their rent on time according to the terms of the agreement. There can be included as a part of the lease agreement a penalty for not paying on time. However, the penalty can't be confiscatory. It can't be confiscation. It's got to be a reasonable late fee associated with the expenses related to carrying it. There's late payment penalties on mortgages, which can be very expensive. So if the late fee is $100 a day, that's unreasonable. And the court would find that maybe you're entitled to a reasonable late fee, but that's unreasonable. And I'll use an aside here. There's also a statute in New York that says that unconscionable contractual provisions are void. So the court could find that exorbitant late fee is unconscionable and could throw the whole thing out. So somebody should take into account that. I can't tell you what that number is. I leave that out there. Just saying that the more that it can be related to a reasonable fee, a reasonable expense that's associated with the landlord's carrying charges on the home, the more reasonable it's going to be found. The more that it can be considered a bonus to the landlord, the less reasonable it's going to be found. So it has to ultimately be decided. You had a question. How should the landlord communicate with the tenant? Well, I can't answer that. It's, how do landlords communicate with tenants? It's however is reasonable communication with the tenant. I would say to the landlord, you're acting more reasonable if, let's say there's if not paid by the day 5, there's a late fee. You're acting more reasonable on day 6 when you send a letter, a notice, email, however people communicate. I encourage you to communicate in writing and keep a copy for yourself. Then there's no questions. To say, today's day 6, understand there's a $25 late fee. For anything after that, you will be charged the $25. It's the more problem gets into is where the landlord doesn't notify the tenant, and then they claim it's a $50 a day late fee, and then when the payment comes in at the 20th day, say, aha, you now owe, however 25 times, you owe another $250 because you're this much late. It all falls back to our original premises. Everybody act reasonably. How would a reasonable person act in that circumstance? And tenants, as well as landlords, I'm telling you, landlords, you need to protect yourself. Tenants, you need to protect yourself. How do you best protect yourself? You show that you are the one that's being reasonable here. You go ultimately and have to, let's say they move out. and they've incurred, over the course of the 2 years they've lived there, they've incurred $250 in late fees. And the tenant then comes to you and sues you because you didn't give them their full security deposit back. You go to court and you say, Judge, here's every letter I sent to them telling it was late. Here's my lease. I gave them all kinds of notice. I acted reasonably. I think you win. So it just comes down to how do people communicate. You don't need to bring in lawyers every time something like that happens. You need to be reasonable and communicate. Likewise, on the other side, let's talk about on the tenant side. If you have a problem, you put the landlord on notice. Let's say it's getting to the end of the lease, and you have an obligation to give 30 days notice, which we'll talk about that in a minute. So you give 30 days notice that you're going to be leaving at the end of the lease. Do it in writing. Keep a copy for yourself. That way the landlord can say, I didn't get the 30 days notice. Say, here's the notice. So it works both ways. So tenants have the obligation to pay. Two, they have the obligation to keep the property up. They have to treat the property as if it's their own, because that's what they're getting. They're getting, for the payment of a fee, exclusive use and occupancy of this premises, exclusive use and occupancy of this premises, for this length of time. And while you do that, you have to treat it as your own. And so the rule is that the tenant must return the property to the landlord in the exact condition as it was received, reasonable wear and tear accepted. And there's that term again, reasonable. But again, I think we can fall within parameters of what, in most instances, is reasonable. If a carpet is 25 years old and a person has been living there for a year, and the door that most people go in and out of, there's a wear mark in the carpeting, that's reasonable wear and tear. And the landlord can't expect to take out of the security deposit the cost of replacing the 25-year-old carpet that's got the wear mark in it, because that's reasonable wear and tear. However, if the tenant has an aspiring young artist, maybe 2 years old, in the house, who uses crayons to draw on the wall, no matter how cute the kid is, and no matter how beautiful these drawings are, it is not reasonable wear and tear to expect that Crayola is going to be all over the walls. So if the walls have to be repainted, that's not reasonable wear and tear, and that the landlord is able to charge the tenant for those sorts of things. And then we can fall anywhere in between. But, big, huge stains on the carpet that didn't exist before are not reasonable wear and tear. And so if they have to be replaced, they have to be replaced. Now, if the living room carpet is damaged, that doesn't give carte blanche to the landlord to replace the entire carpeting throughout the apartment. Now, you get into that grayer area when all the carpeting matches. And the only way to replace it, I think the landlord has to, strange as this may sound, act reasonably. And if it can be replaced in the, it can be done in such a way that can be matched pretty close, or it's divided by rooms and it can be divided out. I don't think a court's going to authorize a replacement of the entire kitchen, the entire apartment. If a stove has a scratch mark on it, that may not mean that you're going to be able to replace the entire stove. And then, of course, we can whittle our way down to where, maybe the stove might have to be replaced. But anyway, the property has to be kept up, returned in same condition, reasonable wear and tear accepted. The reasonableness of it has to be decided by a court. I was involved in litigation where one of our agency clients had rented an entire complex and they got sued because the property wasn't returned in the condition as the parties had agreed. The best, and you sit there and say, if I'm a landlord or if I'm a tenant, how do I protect myself in that circumstance? And my response to you is this. It's a phrase that has been around for eons. Is a picture speaks 1,000 words. Pictures in or video in, and pictures out or video out. Both parties would be well served by taking pictures going in and pictures going out. I do think it's a good idea to have walkthroughs going in and walkthroughs going out, but I also think pictures are really good. And that way you can show to the court what the place looked like when you moved in and what you moved out. And tenants, when you have your walkthrough, really technically it should be after all your stuff is moved, because don't think that you're going to get away with putting the couch over the huge stain in the living room carpet and have the walkthrough and have the landlord told me it was in great condition. And then you move the furniture out and there's this big gaping hole or stain in the carpet. You got to be smart about it. Take the pictures when you move out, and video moving out. It just saves everybody in the long run. I do know that the City of Ithaca does have a very active code office. And actually, the City of Ithaca has some rules related to security deposits. For example, the rule in New York, it's the general rule, is security deposits must be returned within a reasonable period of time. Oh my gosh, there's that term again, a reasonable period of time. But again, I think we can generally agree that a reasonable time, we can kind of define it within parameters. The City of Ithaca says 30 days. I don't think that's unreasonable. If it's 32 days, in the City of Ithaca, it would be a violation of their ordinance. But as a general rule, 30. In 28 days? But if a tenant calls me and says, I moved out 3 days ago and that darn landlord hasn't given me my security deposit back yet. Well, the landlord has to be given time to, one, inspect, and two, to get estimates of what repair costs might be and that sort of thing. So 30 days isn't unreasonable. 2 weeks is not unreasonable. Either way, it's that sort of thing. In a lot of instances, the tenants can't afford to pay for, getting back to what I was originally saying, when you go into a lease, you might have to pay the first month's rent, a security deposit, which, by the way, is traditionally been 1 month's rent or something. There's nothing in the law that says that it's 1 month's rent. It just happens. Some people think it's part of the law because it's typically 1 month, but it's not. It could be anything. But it's typically, so you're paying let's use a month as being security deposit. First month, security deposit, and sometimes the last month. So you have to come up with 3 months worth of rent. And I'm talking about the person that can't afford the 3 months worth of that. There may be people that can afford it and move on. So the person that can't afford it needs money, because if they're moving out of their apartment, of course they've paid if it's part of it, they've paid the last months, but maybe they haven't. Maybe it's just the first month and the security deposit. So you have to pay your last month's rent. Then you have to pay the first month's rent of the new place. Then you have to pay the security deposit for the first place. And so you have to pay 3 months worth of rent to move into the new place. So you need your old security deposit back. So the question is, why can't you immediately get it back? And the answer is because the landlord has a reasonable period of time to return the security deposit. How long that is, again, depends on the facts or circumstances. If there is a walkthrough, the place is completely empty, everything is great, the question of reasonableness gets shorter. Okay? No repairs have to be done. But if a walkthrough hasn't been taken place, the landlord has to be given a reasonable time. Let's say the landlord is not in town that week, they're on vacation, so they're not going to be back for a week, so you got a week until they come back, and then they've got some time to look at it. Then there might be damage, so they got to get a contractor in. Who knows how long that takes to get in. And so you're expanding what the reasonableness is. So again, it comes down to what is reasonable and what is fair for both sides. The so the security deposit has to be paid back within a reasonable period of time. The code office here in the city of Ithaca is very active, and I think that tenants should always talk to the landlord first. If they have problems with repairs and things like that, they could contact the code office. And our office, the Attorney General's office, also has a mediation program where if you have a complaint, you can file a written complaint with our office, which we then send to the landlord to try to resolve those. We actually have a rent security deposit complaint form. That'll tell you how many complaints our office gets. We have a general complaint form, but we actually also have a specific rent security deposit complaint form to handle those particular types of complaints. So the question is that a landlord would say, has been asked to hold the apartment for a period of time, and the landlord asked for a security deposit to hold that particular apartment. That's based on the agreement between the parties. The important thing is I would still do it in writing, because who knows what that means. Now, I don't. When somebody says, okay, the tenant, that is ripe for problems. Tenant says, okay, I need you to hold the apartment for me, and I'm going to give you the $300 security deposit to hold the apartment. My question then is, what does that really mean? Does it mean that the tenant has agreed to rent from the landlord? Or does it just mean I'm going to give you $300 and that if I go in the apartment, you can keep it. If I don't go into the apartment, I get my money back. And I'll tell you that is a terrible, terrible way to do it. You got to get it in writing to say it's a non-refundable holding fee, which is if you choose not to enter the apartment, I'm keeping the money. If you choose to enter the apartment, that was just to hold it, or it'll be used as your security deposit. You really have to define exactly what and specifically what you are going to do with that money. If the parties agree to something like that, that's what contracts are about. Parties can agree to that stuff. Let's morph over quickly, as we run out of time, to what happens. You have that lease and the whole thing is all in place, and it comes to the end of the lease. And what happens? How does it end? The way that we talked about, exclusive use and occupancy is given up. And that means exclusive use and occupancy. So landlords, once you rent, you are getting a fee for letting somebody exclusively use that. You don't have the right to go in. Don't have the right. Unless the parties agree to it. And even if the parties agree to it, it's only on reasonable notice and at reasonable times. Also, the landlord could enter on an emergency to protect his or her interest in the property. So I use the example of, let's assume it's January and you rent to students and the students are home on break. And you hear there's water running. That can cause a problem. First of all, landlord, you'd have the right to go in to protect the property. 2, you better protect yourself. Make sure somebody goes in with you, and you're only in there for that reason and that reason only, and get out and make sure it's locked and make sure you have someone who can witness that it's been locked up. You get a whole host of problems if you just start entering in. Some landlords think, hey, I'm the owner of this property. I don't care what the tenant says. I'm going to go in there because I'm the owner. No. You are receiving a fee for exclusive use and occupancy, and that is exclusive, and you must stay out. So you can agree that they can go in on 24 hours notice or something like that. Put it in the written document and abide by it. And then let's fall back to our reasonableness standard. People, everybody has to be reasonable. If somebody says, the landlord says, I'm selling the property, I want to have somebody be able to look at the property, we need to have somebody go in, talk to your tenant and say, when is it reasonable? Tenant may have valuable things in there that you as a landlord don't want to be accused of doing anything to. So say, hey, we want to really show the apartment. It's 24 hours or 48 hours from now that the realtor is going to bring somebody around. Is that okay? And if the tenant says, I can't do it at 2 o'clock because I'm doing this, that, or the other thing, I'm working, is 6 o'clock okay? And the parties can say, well, no, that it's not available. How about 7? And work it out. Work it out. People have to be reasonable about these sort of things. What ends up happening is people get like this, and they're hard-headed, and I'm going to be there and at that time. Hey, you got to be careful, because somebody could argue that that's not a reasonable time. So you got to work it out. And if you can't work it out, it's going to be up to the judge to decide whether this was reasonable or not, whether the tenant should be entitled to an abatement, and whether or not the landlord should be responsible for damage that was caused because nobody was around when somebody went in the property. I just leave that part of it at that. But anyway, coming to what ends up happening. Because there's exclusive use and occupancy of this property, the only way a landlord can get that back is to sever that exclusive use and occupancy. And the way to sever that exclusive use and occupancy is, one, by an agreement, so that everybody agrees that the lease ends on a certain date. You need a court to sever it if you can't agree to it. And what that means is if you don't, tenants don't vacate, the landlord can go to a judge to have the judge sever and return the use of the property back to the landlord. And that's an eviction proceeding under the Real Property Actions and Proceedings Law. And how does it actually work? Well, let's talk about, there's 2 instances that it can be severed. One is that the tenant doesn't live up to their end of the bargain, i.e. doesn't make payments. Or 2, the lease ends. If the lease ends, your tenant's got to get out. And if the tenant doesn't get out, it's called a holdover. The tenant continues. So the landlord can bring a proceeding to evict that tenant, even though the tenant has been very good about paying on time and is a good tenant. The tenant wants to stay. If the landlord doesn't want the tenant to stay, they can commence the proceeding. The one caveat is that the landlord has to be very careful, is don't accept the rent after the term expires, because if you do, you will have acquiesced in the tenant continuing on. You're better off, if you want the person out, you have to go through your eviction proceeding. Now, you may be entitled to get recompensed for the period of time that the tenant remained in the property and hadn't paid the rent. But if you accept the rent ahead of time, then you can be deemed to have accepted. Now, here's the way that the law works. Is even if you're there for a year, it's deemed that upon the expiration of the lease, your lease converts to a month-to-month tenancy, unless the parties enter into another agreement. And also, absent a otherwise having an agreement, it's presumed to be a month-to-month lease. So if the 2 parties crazily say, yeah, I want to rent it from you, and the landlord says, okay, I'll rent it to you, and they don't talk about how long it is, it's presumed to be month-to-month. And with a month-to-month lease, either party can sever the relationship by 30 days' notice before the beginning of a term. So let's say that you had a year lease. It ended January 1st. You continue to pay the rent, and it comes to June, and the landlord says, well, or the tenant says, either one says, I want to get out of this thing. I'm going to move somewhere else, or I'm going to put somebody else in there. Either party before June 1st, if you're on a month-to-month tenancy from the beginning of a term, it's when the term begins. Most leases are first of the month to the end of the month. It could be a 15th of the month to the 15th of the month. So whenever the beginning of that term is, and we'll use the first of the month because that's typically what's used. You've got to give notice, either party has to give notice before June 1st that they're going to be out at the end of June, or that the lease ends at the end of June. Then the tenant must be out by the end of June. If they aren't, the landlord can commence an eviction proceeding. And we'll talk about how you do that in a second. The landlord or the tenant can't give notice on the 15th to be out at the end of the month, because without sufficient notice, the tenant could be responsible for rent for the following month if they don't give sufficient notice. Likewise, if the landlord gives notice on the 15th to be out on July 1st, the tenant can just ignore it. And it wouldn't be effective until the end of the next month at the earliest, because you have to give at least 30 days notice before the beginning of a term. Just because the landlord gives notice before June 1st doesn't absolve the tenant of the responsibility to pay the rent that's due on June 1st. And the tenant, if they refuse to pay the rent because maybe they can't afford the batch of rent that has to go in toward the next place, they could actually be evicted sooner than July 1st. So tenants have to be very careful and make sure that they still owe the rent for the time that they're there. So what happens with an eviction proceeding? If let's step away from that's the holdover tenant, referred to as the holdover tenant, given proper notice. Let's talk the more typical situation where the tenant hasn't paid the rent and the landlord wants to get out. Yet the landlord has to do certain things. And if the landlord doesn't dot all their I's and cross all their T's, they're out. So the first rule is in a failure to pay rent, before the landlord can commence a eviction proceeding, they must give what I refer to as the first 72-hour notice. They must give a notice to the tenant that rent is due, pay or get out. There are forms available at stationery stores and stuff to get that. And it must be served on the tenant, says pay or get out, and it gives the tenant 72 hours notice, pay or get out. That's a precondition to starting an eviction proceeding. Then the tenant can choose to pay or get out. If the tenant chooses to do neither, that's when the landlord can commence the proceeding. And they commence the proceeding by serving what is referred to as a notice of petition and petition. And the petition notice says you got to be in court at a certain date. The petition says we had an agreement, the rent's $500 a month, rent was due for June 1st, it hasn't been paid, it has to be a condition in the petition that says 72-hour notice was given, the tenant has not paid, and the tenant has continued to reside there. I want the court to sever the exclusive occupancy and give me my property back. Here's another important time frame. That notice of petition and petition, the notice telling them when they have to be in court, and the petition itself has to be served between 5 and 12 days from the day you are in court. So you figure out the day you're going to be in court, you count back 5 days, you count back 12 days, and in that window of time is when the notice of petition and petition have to be served. If it's served too soon, in other words, 20 days before they have to be in court, no good. If it's served 2 days before they have to be in court, no good, and the petition must be dismissed. So between 5 and 12 days, it has to be served. So you can see how there's a gap from the time that the rent is due until the court will hear it. Okay, so then you go to court between the 5 and 12 days of when it's supposed to be. The tenant shows up and the tenant says, I was a little tight this month because I had to pay for my next month's rent. I'll have it tomorrow. Technically, the court doesn't buy that. I mean, you have to have paid the rent on time and it's due that day. If you don't pay it, absent walking in with all the cash and whatever late fee there is, the court will sign what is referred to as a warrant. It's not an arrest warrant. You don't get arrested or anything, but it's a warrant. A warrant authorizing the law enforcement officer to give you your property back. The judge signs that, and then you take that, and I don't know how you do it here in Tompkins County, but at the very least you can go to the civil division of the Tompkins County Sheriff's Office. That's how we do it back in Broome County. Some municipalities may have a constable. Some, I don't know if there's a city marshal. In the olden days, and I say olden days, back when I was practicing, when I first started practicing law, some cities had city marshals who were law enforcement officers and town constables. A lot of them have gotten away with those. You take that to the law enforcement officer because the landlord can't then, let me step back. Landlords cannot do your own personal evictions. meaning you can't go and change the locks. You can't turn off the utilities. You will be subject to penalties if you do. You have to go through court, and then court has to sever the relationship with the warrant. The sheriff, I'll just use sheriff as the law enforcement officer, then goes to the tenant with the warrant that the judge signed and another piece of paper called the notice of warrant that said, this is the second 72-hour notice that says, we'll be back in 72 hours. Either be out or we will throw you out. Now the sheriff, for you landlords, the sheriff doesn't bring their posse in to throw everybody out. All the sheriff's there is to keep the peace. And the landlord would then have to make arrangements to take care of getting this tenant out of there. And the landlord has to act reasonably, such as if the place isn't going to be re-rented right away, maybe you change the locks or do something, or if there's a storage place in the garage, you put the stuff in there. If there is no storage, you may still be acting reasonably, but acting, which means putting it outside, but reasonably doesn't mean removing the property by the second-story window. And just that's unreasonable. The general rule is you just have to act reasonably. Then also tenants have to realize that they pay a security deposit, but the security deposit is just an arbitrary number. If there is damage to the property, the tenant is responsible for the damage that they cause, whatever number that works out to be. So the tenant could be responsible for more than what's the security deposit and could be subject to litigation to be sued for the amount that's owed for damages that occur to the property. So they always need to keep that issue in mind. So once I've never had the situation, it's come close when I was in private practice, to where the sheriff had to show up, or the town constable had to show up at the door just as the tenant was finally walking out after that second 72-hour notice. But I've never had the circumstance where somebody has to move it. But if the 72 hours expires, and the second 72 hours, and the sheriff has to show up and the tenant's not out yet, landlords, you need to have your own group of people that are going to assist you in reclaiming your property. But once it gets severed, that's it. The exclusive use and occupancy expires. The question is landlord comes back with this huge estimate, and the tenant said, well, I could get it done for much less expense than that. It all is fundamentally the same, which is the landlord has to act reasonably, and if it's an overblown expense and it's too much, the landlord runs the risk that if they then try to collect the unreasonable amount, the tenant can challenge that, and the court could decide that the amount being asked is unreasonable. That's where we fall back to the tenant and the landlord communicating to say, we can get this done cheaper. The problem with that is the landlord may say, well, you're doing it on the cheap, and I want it done the way that it was done before, and you get into that mix. Here's a better thing. The best thing is if the tenant knows there's damage, get it fixed. And then that's the problem. If there are any issues related to landlord and tenant, you can contact my office, New York State Attorney General's office. I know also Cornell Cooperative Extension has a lot of valuable information here down on Willow Avenue. You can feel free to contact them. They also have a consumer hotline that you can call. You can also contact the Attorney General's office. We have a 800 number. So it's 1-800-771-7755. And if you call it in Broome County, or in Tompkins County, it rings in Broome County because it's part of our region. If you call it within the 607 area code, it'll ring in Binghamton, and we'd be glad to answer that. It's been a pleasure being here on behalf of the Attorney General. I hope we were able to get through all of the issues that we needed to get through. If we're here on the second Thursday of every month, from 11 to 12, we generally talk about consumer topics, or if you have any personal topics that you want to come in and speak to us about, come in, and we'd be glad to talk to you about it after our show is over with. Thank you very much for attending, and have a good afternoon.